If you contracted COVID-19 during your military service, you may be eligible for VA disability compensation, but there are important details you need to understand about how these claims work. I'm Brad Hennings, a partner at Chisholm Chisholm Kilpatrick. Today I want to walk you through the two main ways veterans can get VA benefits connected to COVID-19 and what you actually need to prove. First thing to understand is that COVID-19 itself does not have a VA disability rating. It is an acute illness, meaning it typically runs its course and resolves. VA cannot compensate you for a disease that is no longer present. What VA can compensate you for are what we call residuals, the chronic, ongoing health problems that COVID-19 leaves behind. Things like persistent respiratory problems, cardiovascular issues, brain fog, loss of taste or smell, or mental health conditions like depression or anxiety. If you're experiencing any of those kinds of lasting symptoms, that's where your claim begins. Now, how do you connect those residuals to your service? Congress passed a law, 38 U.S.C. 1164, that established what is called presumptive service connection for COVID-19. Under this law, if you served on active duty for more than 48 consecutive hours between March 1st, 2020 and January 5th, 2024, and you were diagnosed with COVID-19 during that service or within 14 days after it ended, VA will presume that you contracted the virus in the line of duty. You do not have to prove the link between your service and the infection itself. The law does that work for you. The same presumption extends to active duty for training and full-time National Guard duty performed under Title X orders during that same period. But, and this is important, the presumption only gets you to the door. It establishes that your COVID-19 was connected to service. VA still requires you to show that your current chronic symptoms are actually caused by that COVID-19 infection. That usually means medical evidence, records from your treating provider, and in many cases, a medical opinion, sometimes called a nexus opinion, that links your ongoing condition to the virus. If your COVID-19 was diagnosed and resolved during service, but you are now experiencing long-term complications, VA is required to rate those residuals under the appropriate body system in its Schedule for Rating Disabilities, found at 38 CFR Part 4. For example, if you have lasting lung damage, VA would rate that under the respiratory system criteria. If COVID left you with a cardiac condition, that would be rated under the cardiovascular criteria. There is also a secondary service connection pathway worth knowing about. If you did not contract COVID-19 yourself, but you already have a service-connected condition, say a respiratory condition or an immunocompromising disability, and COVID-19 made that condition significantly worse, you may be able to pursue a claim on that basis under 38 CFR 3.310. The key is showing that your service-connected condition was a contributing factor in the worsened outcome. So what should you do if you think you have a claim? Start by gathering your service records to confirm the dates and nature of your duty during the qualifying period. Pull together your medical records documenting your COVID-19 diagnosis and any ongoing symptoms. If your treating provider has documented the connection between your chronic symptoms and the infection, that evidence is critical. If you do not have a nexus opinion yet, that is something worth discussing with your doctor or with a VA-accredited attorney or agent. You should also consider filing an intent to file as soon as possible. That preserves your effective date, the date from which VA calculates any back pay while you gather the evidence you need to complete the claim.